The famous pilgrims who sailed to America on the Mayflower were only a few of the colonists who came to the New World to escape religious persecution. The freedom to practice whatever religion they chose was very significant to early Americans. Knowing this, the framers of the Constitution created the Establishment Clause in the First Amendment. This clause created a wall of separation between religion and the government. Thomas Jefferson was the first to advocate a wall of separation between the government and religious institutions in his letter to the Baptists of Danbury in 1802. The wall of separation prevented state-sponsored religion and minimized the risk of religious persecution.
Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. First Amendment of the Constitution, 1791.
The Establishment Clause, however, fell short. While it prohibits Congress from establishing a central religion, it did not apply to state governments. At the time of the Revolutionary War, 9 of the colonies financially supported a single religion. Citizens were allowed to practice any religion, but only one received financial support. This seemed unfair to some leaders, including Thomas Jefferson and James Madison. Both had studied the problems caused by the entanglement of church and government in countries such as England and Russia, so both believed a firm barrier should be put in place to prevent intermingling of the two institutions. In his writings titled Memorial and Remonstrance Against Religious Assessments, Madison argued that the government should not be empowered to intervene in religious matters, and that religious institutions should not have any official involvement in the government. It wasn't until the time of the Civil War, however, that the wall of separation could be made taller. With the ratification of the 14th Amendment, the Establishment Clause now prevented states from making laws that affected individual rights protected by the Constitution. It established the Incorporation Doctrine, which essentially nationalized the Bill of Rights, and prohibited states from passing laws that could inhibit these rights.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. 14th Amendment to the Constitution, 1868.
The framers of the Constitution had differing opinions on the separation of church and state. This led to some gray areas in the Establishment Clause, and those gray areas have prompted various interpretations by the Supreme Court over the years. Some courts have taken a broad interpretation of the Establishment Clause and served rulings that supported the belief that the government should not be able to use tax money to provide any kind of aid or support to religious institutions. Other courts have taken a more narrow approach to interpreting the Establishment Clause. Their rulings reflected a belief that the government is allowed to support religious institutions as long as it remains impartial and does not support one religion over another.
We seek a constitutional amendment to permit voluntary school prayer. God should have never been expelled from America's classrooms in the first place. President Ronald Reagan, January 25, 1983.
Courts that have leaned toward a literal interpretation of the Establishment Clause typically believed that the First Amendment only prohibits the establishment of an official religion. Thus, government should be allowed to participate in religious activities indiscriminately, as long as it does not endorse one religion over another. The thing that separates these three types of interpretations is exactly that, separation. And a number of key Supreme Court cases have changed the degree of separation between church and state. One was the 1962 case of Engel v. Vitale, in which a group of parents in New York filed suit because their children were required to recite a short prayer in school at the beginning of each day. The court supported the parents because the religious elements of the prayer infringed on the children's First Amendment rights. In the Abington School District v. Shemp case in 1963, the court ruled that the state of Pennsylvania was violating the Establishment Clause by mandating student participation in Bible readings. And in 1980, this controversial decision was reaffirmed when the court ruled that the Kentucky state government could not require the Ten Commandments be posted in public school classrooms. The Supreme Court has consistently prohibited mandated religious activities in public schools. Conversely, in 1990, it allowed a Christian group to meet on school grounds because the membership was voluntary, and denying the group would be limiting equal access to public facilities. Then, in 2001, the court ruled that a Christian group could use school facilities after hours, claiming that restricting their usage would be a violation of their free speech and free assembly rights.
Who does not see that the same authority which can establish Christianity in exclusion of all other religions may establish with the same ease any particular sect of Christians in exclusion of all other sects? James Madison, 1785.
Throughout its history, the Supreme Court seems to have ventured in different directions with its rulings concerning the Establishment Clause, and it seems to contradict itself on occasion. For instance, the court allows prayer in Congress, and the words, "In God we trust," on our federal currency. But despite some inconsistencies, the court has established rules and criteria that more easily determines if activities are allowed under the Establishment Clause.